Alrighty, let's go ahead and get started. Hello and welcome to PTAB Whispers, a year in review unveiled, hosted by Virtual Patent Gateway and moderated by Philip May, a patent litigator at Groombridge, Baughman, and Stone, whose practice focuses primarily on representation of pioneer pharmaceutical companies in Hatch-Waxman litigation. Philip is joined by Jackie Bonilla, director in Sterne Kessler's Biotechnology and Chemical and Trial and Appellate Practice Groups, Raghav Bajaj, partner at Latham Watkins, Molly Kocialski of Counsel at Holland and Hart, and Lissi Mojica, director of IP and AI at Answers IP. And with that, I'll pass things over to Philip to get started.
Thank you so much. Before we get started today, I just want to provide this disclaimer that the views and opinions expressed in this program are those of the speakers themselves and do not necessarily reflect the views or positions of their employers and associations that they may be part of or any entities that they represent. So with that, as Caitlin said, my name is Philip May, counsel at Groombridge, Baughman, and Stone. So we're joined today by a phenomenal panel. Caitlin provided some brief introductions for them, but I will let them introduce themselves all briefly as well, and we'll take it in alphabetical order. So Raghav, if you wouldn't mind.
Sorry?
Just a brief introduction to yourself.
Sure. So I'm Raghav. I am a partner in Austin at Latham and Watkins. I've been at the firm for about a year and a half. Previously, I was at another law firm doing much of the same thing, all PTAB all the time. I have a relatively balanced docket between patent owners and petitioners, and I've also been experienced over the years in ex parte reexaminations as well.
Thank you. Jackie?
Hi, I'm Jackie Bonilla. I am currently at Sterne Kessler. I've been here for about 6 months, and I also work on different things, all sorts of types of practice for both parties. So it's an exciting time to be there. I have a Ph.D. in pharmacology, and that is my background. And so I like to do the biotech, pharmaceutical, biologics, mechanical device cases, things like that when I have a chance. But prior to being here, I was at the Patent Trial and Appeal Board for almost 14 years. And for the last 6, I was the deputy chief judge there. And I also did a stint as on detail as the director of the CRU. So it's an exciting time to see what changes are afoot and to talk about them. And I'm looking forward to our panel.
Thank you. Molly?
Hi, everyone. I'm Molly Kocialski. I am now at Holland and Hart. I don't have a docket because, like Jackie, I left the agency just a few months ago, and we both have stipulations about practicing in front of the office for a period of time. But when I do get a docket again, I will probably be back in the post-grant strategy and strategic portfolio counseling realm, which would include, of course, anything going on with the Patent Trial and Appeal Board. Prior to Holland and Hart, I was the regional director of the Rocky Mountain, now closed Rocky Mountain Regional Office of the U.S. Patent and Trademark Office. I had the honor of working with Jackie and all the amazing people at the Patent Trial and Appeal Board. Before that, I was in-house counsel for 3 different Fortune 200 companies. And part of my practice there, especially with Oracle, was Patent Trial and Appeal Board work. So that's that. My background's chemical engineering, but I've never actually gotten to use it. So I'm hoping that happens now in my career.
That's fantastic. And then last but certainly not least, Lissi.
Hi, my name is Lissi Mojica. I have been practicing for probably longer than some of you have been alive. for 37 years. I am at Answers IP, and prior to that, where I do all post-grant, re-exam, and expert work, for PTAB, and all things patent office. I was at the patent office for 19 years. I left there as a director of the Central Reexamination Unit. I have been working on the LexisNexis chapter of the PTAB proceedings for the AIA since the inception of the AIA. So I have a very unique perspective on, the inside, the outside, and, since I've had to analyze every single decision and put it in that chapter, it's been a ride. So that's me.
Thank you so much. All right, so today, ideally, we're going to get a chance to talk on all 4 of these topics. We've got a pretty exciting agenda of topics and with a lot of things to cover on each of them. But the plan for today is that we're going to kind of be talking about 4 different buckets. The first thing is going to be Director Squires' October 17th, 2025 open letter and his accompanying memorandum regarding institution, and kind of how the practice at the PTAB has changed since then, as well as the use of director review. The next topic is going to be kind of ex parte re-examinations versus IPRs and related updates from the CRU that were given about a month ago. Third is going to be the October notice of proposed rulemaking, which would impact institution of IPRs going forward. And then finally, the recent presidential and informative decisions that have come from the director's office. So with that, kind of looking at starting with the first topic, which was Director Squires' open letter and accompanying memorandum about institution from October 17th of 2025. So Raghav, I kind of want to address this first question to you, which is, how has the director's, reference to the return of institution authority to the director kind of been impacting your day-to-day practice since then?
Sure. So the most obvious impact is that fewer cases have been instituted, which impacts my petitioner side docket as well as my patent owner side docket. But relatedly, we no longer know, the reasons behind the decision to institute or not institute, aside from knowing that it's, related to the merits or related to discretion. On discretion, we don't know if it was settled expectations that triggered the discretionary denial, FinTIV, the state of the parallel litigation, or what it was. It could be another factor. On the merits, we don't know whether it was a claim construction that the director disagreed with, or the mapping of the art to the claim wasn't clear. Again, no guidance, no real knowledge or insight as to the reasons behind the denial or the institution. Whereas before we used to get these 30, 50, sometimes 70-page institution decisions walking through the art, walking through the arguments to give the parties a way to guide the rest of the trial. We don't get that anymore. There have been very isolated instances where the director has indicated that an opinion was forthcoming, and those opinions do shed a little bit of light, but that's by and large the exception, not the rule. And so because it's, we're not getting any of that reasoning, it's hard to advise clients on the petitioner side on whether to go through the time and expense of preparing an IPR petition. You may have very strong art, you may have clear-cut claim construction positions, but you don't know that your story for examiner error or that your merits are compelling enough to the director to overcome, what might be the discretionary circumstances that are cutting against your case. And as a result, a lot of clients are just opting not to test the waters, and that really may be the point of the new policy.
I want to chime in with that. I think that the written decisions were great for both the petitioner and the patent owner. They gave you guidance as to where the patent, the PTAB, where they thought the weaknesses was on both sides. They didn't just say, okay, this is a great argument or whatever. They were very specific, and as you said, it helped both the patent owner and it helped the the petitioner. So I think that in this case, if it's to help the patent owner, part of these policies, and perhaps going back to that written response would help the patent owner as well.
And I can add on to that too. A lot of, and this goes what was mentioned before, there's just been so much change since March, and the change seems to keep coming almost on the weekly. And that in itself is something that I've heard from stakeholders are expressing a lot of concerns about. Just the continued changes. It makes it really hard to keep track of what's going on and to even know what the rules of the road are. Precedential and informative decisions and director guidance and the things like that can be very, very helpful. But some people aren't even sure if that's steady. So they don't even know if what they read today is something that will still be useful to them later. And one of the changes that happened in October, of course, is that the director himself, by himself, he may have people helping him, but he is personally making those decisions about whether to institute or not. And some have expressed concerns. How does the director of the PTO, who's running the USPTO, how does that person have time to personally ensure that he's making all the right decisions in all the cases? Others have expressed concerns over the summary notices. We were just talking about that. These are basically thumbs up or thumbs down. It's a list of cases telling them what bucket they fall in, either, denial of institution on the merits, the discretionary denials, whether it's been referred to and whether it's been granted. And so that's all you see is the list. And some have talked about how there's concerns about transparency. What exactly is happening behind the scenes that's motivating outcomes in cases people don't know. On one hand, a losing party may actually welcome a summary notice because then they have no bad information they're getting from the office. So this may allow them to make the exact same arguments somewhere else without having any negative connotation against them from something the office said. But on the other hand, when you have absolutely no information about why it was denied or not, it may be difficult for the losing party to know what happened, what went wrong, what they could do differently next time, and how it might impact something like director review. They aren't even going to know, like, was there an error? Was there abuse of discretion? Things like that. They won't even know. And in a situation where a trial is instituted, now both parties have no idea what's going on. They don't know what the board's view are on claim construction, the strength or weaknesses of different grounds or evidence or applicability of prior. They just don't, things like real party and interest, like they just have nothing to go on. And in an instituted trial, a patent owner may lack enough information to know things like, should they file a motion to amend? Should they, in light of what's going on, should they think about filing a request for reexamination or reissue? They just won't have that kind of information. And then on an extreme level, to the extent, that the office is engaging in, a constitutional violation or APA violation, like, how do you even know that? If you're going to say that there's a problem there, you don't even have enough information. So I think people are concerned about the lack of information that they're getting from a director who is doing these on his own when he otherwise has an extremely busy schedule. So that's.
I'll add on to that, Jackie. I think that the biggest thing that concerns me about all of that is even what happens if the office makes a typo. Not like we haven't seen evidence of that recently, especially with respect to the public notice about the Pokemon patent, where the public notice used the wrong number to reinstitute or to sua sponte institute reexamination by the director. Right? Like, you have no recourse because the Federal Circuit has made it clear they're not going to take a mandamus petition on any kind of a discretionary denial, period. Like, just period, right? Like, I think every single mandamus petition has now been denied. So you have no recourse.
I think there's one still pending.
Is there one still pending, Raghav? Okay.
One
out of 14, 15?
I think that's right.
So I don't know about you, but those are not good odds if I'm talking to a client about what recourse you have. And yes, there's a director review, I'll say procedure, all of those other kinds of things that you can try and institute. But I mean, again, on this discretionary denial, you're now asking the director to second guess himself. And not, I'm just thinking that doesn't have a whole lot of success rate there either. So it just is the fact that, once this up or down decision is made without any transparency, without any recourse for you to fix it. And again, like I said, what happens if it's just an innocent typo, and the wrong case gets denied that should have been instituted, but you have no recourse to fix it. So I think all of those things are part of what is so unsettling. And I would say, from what I have heard from people, again, not having a docket in front of the office right now, but what I've heard from people is just that it's unsettling for everybody. No one's happy. Which may be the point. I mean, if no one's happy, then things are working. Maybe? I don't know.
Well, I'm going to chime in real quick on that one. I honestly, when I was at the patent office, and since then, we've commented on a lot of the rules, and every time you try to like circumvent something, you change the rule or you change your procedure, there's only so much stuff you can think about, right? And so, like here in this instance where they're saying, okay, we want to get through these as quickly as possible. We're just going to, instead of, going through, putting all that effort in at this point, we're just going to move forward, which I'm sure that's what the rationale was. But the consequence of that is now, not only are we not getting information, we don't have clarity, but it is costing both sides a lot of money, because since you don't have clarity, you can't focus on what the problems are and what the claim construction or whatever the issue is. You have to now go into Pandora's box and try to figure it out. And the only way you can figure it out is if you look at everything. And now both sides have to look at everything to see whether, what should they do, or where should they go to? Should they file a director review? If not file a director review, go to a re-exam, stay in litigation. Whatever the strategy is, it's going to be at a 10 times cost of what the next step would have been if we had a little more information.
Agreed.
Yeah, and to follow up on that, are you seeing this impacting more on the petitioner side or on the patent owner side? Or is it just kind of really evenly distributed?
Yeah, it's both. I mean, both people have to go into the nothingness of information. So since you don't have the information, you have to look at everything and see what's going on.
Yeah, and I'll add to that.
Sorry, go ahead, Molly.
Yeah, I think I've heard Director Squires speak. I've heard Deputy Director Stewart speak about, the kind of the goal of, they call it quiet title, but I think settled expectations, which I did not mean to make that pun. But well done me. But right, like they want things to be certain with respect to the patent and its ability to be enforced and rights. But instead, what they've done is injected more uncertainty into whether or not this is going to go forward on both sides. And like Lissi said, the biggest uncertainty that's coming is cost to the clients. It can be really tough to advise someone like, hey, you've got a great argument, but I don't know if it'll fly. So now you're just stuck doing something in district court, and that's going to cost you 2x to get to a validity decision what it used to cost you in order to do something in front of the Patent Trial and Appeal Board, if you can at all. But Jackie?
No, I was just going to say that I do think it costs on both sides. I think there are rare instances where a party may be glad to not have it there, but I do think that people, most of the time, it will impact the people who lose in whatever side they are, because they won't know why they lost. And so that's, it really goes to how you deal with your practice and how you either file petitions or respond to them when they're filed against you. Like, what do you do? And so that's, I think that's the real frustration. I think, Molly, your point about cost and the difference of cost and the different types of forms and things like that are also impacted.
So one last question to kind of close out this topic is, what trends have you noticed from the IPRs that actually have been instituted since October 17th. I think
by and
Raghav,
large, they are, yeah. By and large, they are PGRs and IPRs on patents that are newly issued or issued within the last 5 years. That is typically the majority of the cases that are instituted. There are some outliers, but we don't know why they're outliers. And that's, part of the frustration with the lack of reasoning. And then there are, many cases where you have a parallel litigation in a fast-moving jurisdiction like the Eastern District of Texas. You'll see those cases being consistently denied, whereas other cases that have litigation in a jurisdiction that moves a little bit more slowly, those may get instituted.
You also have examiner error. I think that that's something that wasn't as important before. So they're looking to see if the office made a mistake in issuing the patent. So
just to be clear, I mean, error was always in play because that's often the case if you're going to institute a trial. But I think they're being more specific about it now. It can't be that the examiner missed the fact that a prior art exists. It means an affirmative error, like they missed a limitation or they made a mistake in a statement that they made, or they affirmatively missed something that was in the prosecution history. So they're talking about an error you can identify in the prosecution itself flat out. And that's always been a consideration. It's not that part isn't new. It's just that they're putting more emphasis on that as opposed to the fact that the examiner, for example, missed finding a prior in the first place.
And that flips the practice a little bit because, prior to the most recent examiner error focus, you're right, examiner error was a focus, but a lot of clients were looking to file IPRs on art that was entirely new, that filing something with a prior art reference that was mentioned in the file history, put a target on your back for denial under 325D. Nowadays, it's almost as if you want to use the primary reference that was in the prosecution history and identify the error that the examiner missed, because that gives you a better chance at institution, rather than pointing out that there's a wealth of prior art out there and the examiner could have found any one of these 10 references talking about this widget, but the examiner did not.
Yeah, I agree with that. I think that's really like the needle that we're threading now, right? That it's not just that there was an error by the examiner. It's not just that the prior art was in the record, but at this time the prior art being in the record helps you from the cases that I've read, and the fact that they missed, like Jackie said, they missed an element. And I'm not saying this wasn't there before. It's just these are the ones getting through the door.
All right, well, that was, there's definitely a lot more to say on that topic, but in the interest of trying to cover as much as we can today, I'm going to move us on to our next kind of main topic area, which is ex parte reexaminations versus IPRs, as well as the CRU. And so, Lissi, can you just offer for the audience a brief introduction to what the CRU handles and who staffs it?
So the CRU started around 2005, and they handled re-exam then, and then they added reissue. And the CRU is a group of very highly specialized examiners that just focus on both re-exam and reissue. So they know reissue and re-exam inside and out. And it was started because there was a lot of inconsistencies going on in the core, and nobody wanted to touch those because they were just difficult cases. So now the CRU, unfortunately, has been reduced by like 30%. And this is based on a webinar from the Patent Office that they had a couple of weeks ago, that there was like a 30% attrition. And from my understanding, a lot of the cases that are coming in, a lot of the re-exams, there's been an explosion, right? But the question of whether you should file a re-exam or an IPR had already been in existence because of the cost between the two, and whether the cost-benefit analysis of filing an IPR or filing a re-exam. So in the last, I would say 3-4 years, the number of re-exams was going up because the pendency of re-exams had gone down. You could get a through a re-exam prior to appeal in 12 months. And so it was getting even quicker than IPRs. And so, but there's, you had two camps. You had the people who really wanted to participate and they had the money, so they went IPR, and then you had the people who went re-exam. But now you're being faced with, the uncertainty of what's happening at the PTAB, and now you want to go to the CRU. And right now, the pendency is okay, but what's going to happen when people refile all those cases that they had been returned because they had some issues with them? People are taking their IPRs and just packaging them and repurposing them for a re-exam. And then, so some of the most, I would say about half of those cases were returned back and weren't given a filing date because they had errors, they didn't meet the requirements of a re-exam. Well, they're just going to fix them. And then the CRU is going to be bombarded with all these new re-exams. And what is that going to do to pendency? I mean, the only answer to that is it's going to go up, right? And then what the pendency of reissues, which is another avenue that the patent owners can take if they want to fix any issues that they have in a patent, and they can redo their claims and, focus more on infringement, whatever you want to do with a reissue. But the pendency on a reissue was already through the roof. Like I have reissues out there that I didn't get a first office action for 2 years. So, and that shouldn't be the case in the first place. And that's when they were at full stream ahead. Now there's 66% of them. So that's where we're at.
I agree with Lissi on that. I think, when you start talking about what has happened at the office and then the federal government writ large, right? Like the office didn't really have a choice about participating in some of these programs like the Fork in the Road or Vera VSIP or anything along those lines. When you're talking about early retirement, you're talking about the people who are most experienced, right? That are like, hey, I'm just going to take the out. So I think, with respect to that, the office didn't have a choice about doing some of those programs or participating in some of those programs. And that is what led to, I think most of the very experienced people leaving the agency. One examiner that I know calculated that somewhere close to 10,000 years of experience walked out the door on October 1st when the Fork and most of the Vera VSIP stuff actually hit the office. But, so there was a lot of experience that walked out the door those days. I'm not sure, right, about how they restaff, because it's not like you can hire a GS7 into the central re-exam unit. You need someone who is very versed in the procedures of re-examination and reissue in order to hire from that point.
And examination. I mean, you have to have.
They may have. They may have a ready-made set of people who are very experienced and very knowledgeable for that. So, because, right, like, and we talked a little bit about the trends, but I would just say with respect to IPRs, people have voted with their feet. And I think there were 30 IPR petitions that were filed in December, or was that January? And that's the lowest it's been since the enactment of the AIA. I think there was 30 in September of 2012, and then it jumped to 50 IPRs that next.
I can present the stats on that if you want.
I know you have them, Jackie.
Yeah,
but
no, I was gonna.
We haven't seen numbers that low since that time frame when the procedures were brand new.
Yeah, and so
and
Jackie,
just to
sorry,
comment
Jackie,
one quick thing.
What trends have you seen? Sorry, a little bit of a delay.
No problem. I just wanted to comment quickly the staffing issues. Not only have a lot of people taken early retirement, and you don't have people that have the experience, but from what I understand, I'm not an insider like many of the rest of the panel. I know that morale at the office is incredibly low. So even if you were to want to take this job, it's not a good job to have. have. Or if you were outside and you want to join the PTO, it's not a great place to work. So why would you take what, maybe a comfortable position and move to the PTO where it's a less favorable working environment?
All right, guys. I think we need to refocus, but
Why don't I present what's been happening for the stats that we've seen, the interplay we've seen between them. I can do that a little bit to provide a little bit more background of what we're talking about. And one thing I just wanted to remind everyone is that ex parte re-exams have been around since the 1980s. And after that, inter partes re-exams have been around since 1999, and they were actually replaced by IPRs with the passage of the American Events Act. The passage of the American Events Act, it ended interferences and it replaced inter partes re-exams with IPRs and created PGRs and CBMs. So that's sort of the background. So the idea that we have, for example, an IPR or something like it, that's not new with AIA. It's just a permutation of it, if you will. But one thing, and we talked about this already, but we've seen a dramatic drop in institution rates starting in March of 2025 of any IPRs and PGRs. And that eventually resulted in a drop of AIA petition filings as well. And as IPRs have become more limited under current policies, parties have expected that, as one commentator said, they said the validity challenges aren't going to end. It's just a matter of where they're going to take place. So we've seen them take place more in district court and ITC litigation and also in ex parte re-exams. We've seen requests for re-exams go way up. And then just to give you a perspective, so if you look at institution rates by calendar year, in 2024, it was about 2/3, and that's what it had been for a really long time, give or take. There was a little bit of a dip with FinTIV. It went down to a little above 50% right after FinTIV came into play, but then as people learned the rules of the road and what to do and things like cetera stipulations and the like, it went back up to about 2/3. And that's generally what it is when things are steady and people understand the rules of the road. Starting in March, as you know, there started to be a lot of new discretionary denials that were brand new and a surprise to a lot of people. And that led to an institution rate in 2025 of 44%. And in 2026 so far, this is just for January and February, but it's around 25%. So that's a pretty dramatic drop. I will say that the institution rates by technology does differ. If you look at those institution rates since March of 2025, overall, it's about 36% since then. In the electrical arts, it's 29%. In the mechanical and business method, it's about 43%. And in the biopharm and the chemical area, it's closer to 60% at 57%. So it does depend on the technology area, but that also might depend on the kind of filings that they're doing. So interestingly, on the petition filing rates, before recent events, we saw about 100 to 110 petitions, AIA petitions of some kind filed per month. In December, it was at 35. In January, it was 48, so it went up a little bit. In February, it was 32. So we're looking at about 1/3 of what we're used to seeing in filings themselves. Now, interestingly, as we already discussed, inter partes requests filings have gone up. And in fact, in October, the AIA filings and the ex parte re-exam filings crossed. And ex parte re-exam filings actually surpassed AIA petition filings. So for example, in December, ex parte re-exam requests were over 110, but they've been closer to 70 or 80 in January, February. And just to give a perspective before that, it was closer to around 40 per month. So the two forms and the two ways of challenging patents have switched. And of course, as I think Lissi pointed out, the USPTO did a PTO hour on the central re-exam, and they did talk about the fact that they've lost about 1/3 of their people. I think they said they've lost 32% of their people since all of this started, including SPEs and things like that. So it's getting hit pretty hard. So I think it will be worth watching to see how the office and the CRU handles the fact that their workload has gone up by 2 to 3 times, and they've lost 1/3 of their people. And I'll just reiterate that finding, in my time that I was at the CRU, I was just incredibly impressed, as I was at PTAB, at the talent of the people there, just the level, the skill set, and the subject matter expertise. These things are very complicated, both in terms, obviously, of the patentability, but also on the procedures. There's all sorts of things that go on in these cases, and you really need to have high-level people. And so when you lose your most talented people, the people who are the most experienced, it will have an impact. And you can hire, you can try to hire from the outside. I think at the CRU in particular, that's a challenge, because you need people who know how to do examination. And traditionally, they've hired from very experienced top-of-the-line examiners in the core. That's been who they hired. And you can try to hire people who've never done that before, but it's going to be a steep learning curve and all sorts of stuff. So they're up against some challenges, and I look forward to seeing what happens next.
And Jackie, I'll just add to that, because the central re-exam unit examiners were never on a production schedule prior to the last 6 months, where they did the pilot for the production and all of that. And, dropping a brand new person into, that kind of a production era, that's just a recipe for disaster. So I think, the problem that they're going to have with the staffing is definitely going to come to a head sooner rather than later. Now, there are many, many talented people. I wholeheartedly agree with Jackie. The best part of working at the USPTO, and I know Lissi feels the same way, the best part of working at the USPTO was the fact that we got to work with really smart, dedicated, capable, amazing people. So there are lots of people there, and I know that they have the ability to solve that problem. So I am waiting to see what they're going to do with respect to kind of right sizing the Patent Trial and Appeal Board, now that their workload has been cut by 2/3 on the AIA side. And they're reducing their ex parte appeal pendency and inventory to, honestly, they're issuing more decisions on the ex parte side per month than they're actually getting in. So they're going to reduce that inventory down. And then, of course, you have this opposite side on the CRU with the staffing. But it's more than just the staffing that I think is a concern for a lot of people when you're talking about the difference between an IPR and a CRU or re-examination. And I'll just completely admit it. Anybody who's ever flown with me knows that I am a control freak, and I hate flying because I'm not driving. So, right.
And please don't. Please don't.
I'm not a good driver in any sense, but the whole thing about the re-exam from a petitioner perspective, or for someone challenging the patent, is really that you just throw it over the fence, and you lose control of the proceeding almost, as soon as that substantial question of patentability is instituted. So I know that that's a factor for a lot of us in the world, that may have control issues like I do.
So I wanted to chime in here real quick. But first, the stats, I think that there's, they're saying it's 25 to 35%, but the numbers are much smaller. So it may seem like more than what it is, because, if you have 2 out of 3, it's 75, but if you have, so then I think that there's actually less numbers, in fact, that are being instituted. But my big thing is that what we've really lost here is the ability to, and no one's talking about it, is the ability to be able to settle. So when they were enacting the AIA, I was at the director of the CRU, and we were coming up with ways, talking to the policymakers and coming up with ways. What was the difference and what was needed for inter-party re-exam to change in order to make it quicker? And the biggest thing was was quicker and more effective, and what people needed and wanted, right? And the most important part was the ability to be able to cut the strings at any time during the proceeding, except maybe later after, in later times, it's more to the discretion of the PTAB judges. But now there's no settlement. So the patent owner has lost that ability to settle. And so even though they don't like the re-exams, they were settling. Well, I'm sure that Jackie can tell us, but the percentage, I think it's like 30% of the cases settled. And now with these clients, and I've always, I've always been a proponent of, if you don't have the money or the time, file a re-exam, because you can always file a second or third re-exam to correct whatever's going on in the procedure. So you really don't lose control of what's happening. But the issue is that with a re-exam, when you want to settle, you settle before you file. You're going to tell them, look, once I throw this over the fence, you're done. We can't take it back. So that's actually a stronger bargaining position than an IPR, because you can throw an IPR over the fence and then you have the ability to withdraw at certain stages. But once you throw in the re-exam, there's no, the patent owner is stuck with whatever you threw over the fence. And that's been extremely, I think I've settled, I've had people settle more re-exams than I've ever seen. And I've seen hundreds and probably, prosecuted thousands. It's like, it's much more of a, we just have that ability to settle here and not in an IPR anymore. If you don't get it, if we don't have the IPRs, the settlement is out.
So I'll just say one thing. I know we want to, in the interest of time, move on, but I would just say that there are pretty significant differences between ex parte re-exam and what happens in an IPR or PGR. And I would tell everyone that, notwithstanding everything that's going on, all of it is viable. And if you're going to challenge a patent, or if you're thinking about you might be challenged, you really need to think about the interplay of all of these. So there's lots of differences, and you really need to keep track of it all. Maybe that's for another presentation another day when we have a little bit more time, but it's definitely something that you need to talk to your patent attorney about.
Thank you, everyone, on that. All right, so I want to move us along to our next topic, which is the October 2025 Notice of Proposed Rulemaking. And I feel like that might end up eating the rest of the time that we've got today. But I know that people have a lot of feelings about this one. So, the Notice of Proposed Rulemaking has a lot of significant changes included in it. I think the two biggest ones, at least from my perspective, are kind of the requirement for that enhanced stipulation that requires the petitioner to stipulate not to challenge any claim on any 102, 103 grounded litigation. And also, what I'm going to call the quote unquote one-shot rule. So Jackie, can you provide us at a high level the comparison between how IPR procedures are working now versus what's being proposed in the Notice of Proposed Rulemaking?
Sure. So there's a few things in the NPRM. One of them you just mentioned is what we call a super stipulation. It bars institution or maintaining all of these rules. This NPRM impacts IPRs, not PGRs. But it says that it bars institution or maintaining an existing IPR unless a petitioner stipulates not to pursue any invalidity challenge with respect to 102 or 103 at all. And just to contrast the way things are today, currently under FINTIV, stipulations are optional. And they often involve a cetera stipulation, which relates to what a petitioner raised or reasonably could have raised in an IPR. So that's based on patents and printed publications. So this stipulation that they're not saying is optional, they're saying we won't even look at it. You must do it in order for us to even consider whether we'll consider going forward. It's a requirement to even get in the door, and it's even broader than what can even be brought in an IPR. The second requirement of the rule will bar institution or maintaining an IPR if another form upholds the validity of any challenge claim under 102 or 103. And this effectively creates kind of a new estoppel provision. And just to contrast with what the law is by statute, it says under 315E, the estoppel attaches to the petitioner, its real party, and interest of privity in relation to claims after a PTAB has issued a final written decision. So this is creating sort of a new way to put estoppel at the office. Another one bars institution or maintaining an IPR if an earlier adjudication in another forum, so this would be in the district court, the ITC, or in a final written decision in a PTAB under 102 or 103, if that is more likely than not that they will end before the date of when a final written decision would happen for the IPR, the petition that's just filed. And just to compare and contrast to what is true today, at least as of before a lot of changes anyway, FINTIV considered 6 factors. It considered factors in relation to the district court and the ITC, and it considered things like whether a stay existed or was likely to exist, the investment in the proceedings, whether the petitioner or defendant were the same party, and the merits and things like that. And we also had 325D, or advanced bionics, which asks if the same or substantially the same arts or arguments before the office, and if so, whether the director erred in a matter that was material to patentability. And then, of course, we just had the estoppel provisions that I just said. So this is brand new, that we would bar institution or even maintaining one that already exists if another form is likely to go forward and finish. It's more likely than not. And so that will be a real interesting one. How do you even figure out that, and what happens if trial dates might move? Just all sorts of things. Another thing that's in the proposed rules, which is sort of interesting, and it might be left over from the bifurcated process rather than what we actually have today, but it says that a PTAB panel may refer a matter to the director to decide whether to institute an IPR, notwithstanding any of the above rules that proposed rule that I told you about, when exceptional circumstances exist. It's not clear how that would work today when the director is deciding all the decisions on institution. But interestingly, the memo makes clear what is not extraordinary circumstances. So this doesn't include newly discovered prior art or even new case law, for example, by the Federal Circuit, except for Supreme Court case law. So it basically says an exceptional case to go forward is if a brand new binding Federal Circuit case law happens. Apparently that doesn't qualify. So that's sort of an interesting side twist. Not exactly sure what that means. The comments were due in December, and they got over 10,000 comments total and several thousand individual comments. And so I think we'll see where this goes next and what they end up doing. I'm sure they got lots of feedback, and hopefully they're actually going through it.
Well, thank you for that. That's a really helpful, comparison of the existing procedure and what's in the NPRM. So, Molly, I'm going to turn to you to start with the stipulation aspect of the NPRM. What concerns do you have about this new proposed rule?
Wow. There's lots of concerns, right? But I think it goes back to something that Jackie said that I want to pull a thread on a little bit. I do think more than anything else, the biggest change for practitioners these days is that things that used to be kind of a knee-jerk, I'll call it a knee-jerk, but things that used to be an automatic consideration are no longer an automatic consideration. Like, deep thought has to go into what you are going to do when you are faced with challenging a patent, or if your patent is being challenged. And it isn't enough to just look at it from one aspect. It has to be where you have the entire landscape in front of you, and you're going to have to make decisions holistically. And you may have to make decisions, especially if, like, the NPRM goes through and becomes a final rule. You may have to make decisions not just with respect to your own actions and your ability to maneuver through, this patent threat, whatever it might be, whether it's to your patent or to a patent that, is owned by someone else. You've now got to also consider what other people in the marketplace are going to be doing, especially when you start talking about that one-shot rule. So, right, my biggest concern with the Sotera Plus stipulation, or whatever you want to call it, or the supercharged stipulation, as I've heard it called, the biggest problem for me is just that you give up the ability to challenge using anything at all, right? And what Sotera did was allowed you to keep your system art, right? The I did it first art that you might have that was based on, your own systems, your own documentation, your own, printed publications that weren't necessarily in front or wouldn't qualify as prior art in front of the agency. But right, you got to keep those and use those for yourself or on sale bar or anything along those lines, right? Now you're giving all of that up. If you decide that you want to go ahead and file an IPR, and that may not be worth it for some people to discuss. The other part of that is, the patent owner might then not know about what is coming towards them elsewhere in other litigation as they go down the line. So I think that's one thing that's really unsettling is just this kind of, I'll call it, raising barriers to challenging that patent. And there are patents that need to be challenged, right? I mean, I think all of us are aware that while the office does an amazing job with what they're given, I think all of us are aware that, right, no organization is perfect. And there are patents that do need to be challenged and that should be challenged. So, and doing it at the expense of district court litigation is actually a huge tax on corporations and clients and patent owners, versus kind of what the Patent Trial and Appeal Board procedures were meant to be, which was kind of taking the validity question off the table, and moving things at a much more expeditious and cheaper route. So I'm concerned about that. And in fact, when the NPRM came out, I remember talking to a friend of mine that's still in house, and I just said, double or triple your patent litigation budget. You got to go ask for it now because it's happening. There's just no way that someone who has an on sale bar or the I did it first system art argument is going to file an IPR. They're going to challenge it in district court.
And I'll just add one thing. And sometimes when people talk about this, that, their memories are short. But, one of the things that I did do when I was at the office in my role is we thought about what feedback we were getting from stakeholders, what would be fair and balanced, what procedures we needed to be put in place. And frankly, all the way up until 2025, there was a great deal of work that went on there for at least 7 or 8 years. I mean, things like General Plastics came about in 2017. There was a lot of work that we did under Director Yonku. So this was the first Trump administration to deal with these things. There was a lot of thought that went into it. There was lots of asking for feedback from the stakeholders and things like that. And so when thinking about what we're doing, it's important to be fair and balanced and think about all the feedback we've gotten in the past, how much of this stuff is sort of brand new coming out of thin air that maybe nobody even asked for before. So it's just sort of interesting to see where things are and to remember where we are and the amount of work that has already been done and how it was working before any of this. Because I know a lot of that work was intended to make things fair and balanced and make the rules of the road clear and to give and try to be fair on all sides. It's not good when you start getting out of balance of who you favor. And so the work has always been intended to do that. And so it's something I would flag for people to make sure that we're still doing that, because when things get out of balance, I think it starts becoming out of whack for the patent system at large. So you really need to be careful. You can't just think about plaintiffs in district court litigation. You have to think about, most people who are innovators, they have to think about their own IP and they have to think about third-party IP and freedom to operate, whether they're going to get sued or otherwise. Like everybody can be on, unless you're not in fact an innovator, not putting anything on the market, you really do have to think about those things all of the time. And so it's really important to make sure that we're balanced in that regard.
But I want to add as well that, everything has unintended consequences, right? I was not a fan of Sotera at all, right? The problem with Sotera in the previous administration from the outside perspective was that, from a patent owner perspective, was that there was no consequences when the stipulation was violated in court at the patent office, right? So you filed the Sotera stipulation, which was a stipulation that was done in court, but filed with the patent office. And if you filed it with the patent office, then you basically got an automatic institution rate of at least one of the number of serial patents that you filed. So the issue is that when they wrote this, they had that in mind. There was a lot of patent owners that had a lot of problems with the Sotera stipulation, and they maximized this Sotera stipulation. But now what the consequence of this in a, as again, you write the rule with thinking about one thing and then something else comes up. And in here, there could be gamesmanship from the patent owner in that they can even have somebody file an IPR that's not that significant. And then they're barring everyone from being able to challenge that patent again. Or you could sue someone that just doesn't have the resources to put into an IPR what needs to be put in, and they put it in and then it's gone, right? So these are the things that, when they file, when you do a proposed rulemaking, and now that you have the all the comments, because there were a lot of comments that did come in, you have to take that into consideration. Under the previous administration, we had a lot of rulemaking packages that came out, and everybody responded, and things did change. So hopefully they'll look at the responses and be able to see that perhaps this is not the best approach to limit it this much. But there should be some, if you're going to file a stipulation that's going to guarantee that this is going to be instituted, there has to be some bite if you don't stick to it.
So I would just comment to that, Lissi. I think a lot of people think that a stipulation impacts what happened in district court. So it's probably district court is probably the place to deal with if somebody doesn't do what they've stipulated to do. I will say also, though, it is clear that if abuse is happening and you can demonstrate that, the office will deal with that. So I just wanted to flag that on the stipulation thing. It's not an absolute free-for-all. And the PTO doesn't have any control over what happens in the district court litigation, whether the district court follows it or not. That's something the district court is going to have to take care of.
And so, going forward, how do you really see how do you see the stipulation requirement working in practice, given the fact that there were kind of those situations with enforcing the Sotera, and there still kind of are some difficulties in enforcing a Sotera stipulation, both in the district court and at the PTAB. If a party includes the stipulation, they get instituted. What happens if then they go to district court and they make any sort of 102, 103 argument? And how do you see this all working out?
Well, the director has, the director hasn't been shy about deinstituting proceedings, so I could absolutely see that happening. But, as, Jackie and others had pointed out, the district court can also act and say, well, you made the stipulation, I'm not going to let you introduce these 102, 103 arguments. So both forums have enforcement mechanisms, and we'll see which one acts first. But in the district court, if I were in that situation and I brought it up, I would feel very. I would worry a lot about my chances going forward in front of that judge if I were to boldly violate my own words.
I wholeheartedly agree with Raghav. And I would also add, I don't think the director would be shy. And I do think that, like those kinds of bad actions are also one of the equitable threads when we get to talking about the decisions that have come through. I think that's one of the equitable threads. So if a new petitioner can paint that patent owner, even on other patents perhaps, as a bad actor, I don't think, and someone willing to violate stipulations or do other things like that, I think that reputational effect is going to affect people even in front of the office going forward.
All right, and then want to just, before we run out of time on this topic, also make sure that we give a fair thrashing to the one-shot rule. Molly, I'll ask you to kind of to lead this lead this one as well. What are the concerns with this one-shot requirement?
It's a race. I mean, it basically creates a race to challenge the patent, amongst multiple defendants. So, right, like if there's a patent owner that is challenging, and I think it will involve a lot of strategy on behalf of the patent owner to kind of choose their first defendants wisely, because right, that first set of defendants is going to be the people who have the ability to go file the IPR perhaps first. And so I think it's going to be interesting to see how that works out. I suspect, right, like it will involve lots more conversations amongst innovative companies, and along the lines of like, well, who's best suited to go do this? And if the plaintiff chooses, or the patent owner chooses to sue someone very small that doesn't have the ability to actually do an IPR and may not have the system art to go forward in a district court litigation, like, are we going to see kind of the defense bar selecting who's going to be going forward on the IPR perspective and those kinds of things? And I'll be honest, right? Like, I again, going back to the agency and control thing, I'd absolutely hate it to watch somebody else go forward in an IPR that I didn't think was good. I mean, we've all seen it, right? And we've all commented on it. We've seen kind of those things happen already in the marketplace, but at least like other people's rights weren't affected, and other people's abilities to challenge weren't affected. And I think they will be now, right? Because this is basically one shot. You're done. Once that one challenge to the patent happens, no other challenges can happen, at least at the Patent Trial and Appeal Board. You could still challenge in district court or the ITC, but again, that creates that tax on the companies that are doing the challenging, as well as the tax on the patent owner, because an ITC litigation isn't fun for anybody. So I have huge concerns about that, because I think it's going to lead to a lot of strategic maneuvers on the part of patent owners, and I think it's going to lead to some interesting conversations amongst people who are typically defendants.
So I know we've talked about a lot of the challenges created by the NPRM. Does anybody see any upside to either the stipulation or the one-shot requirement?
If you're a patent owner.
Specifically, to be more specific, it's very plaintiff friendly. So if your only concern is being a plaintiff, if you don't have to worry about being a defendant for whatever reason, then this is very, very favorable. It'll be favorable to you in terms of settlement and all sorts of things. So in that sense, it depends on who you are and where you are in time on a particular matter. I mean, if you're a plaintiff, you don't want anyone challenging your patent. And to the extent that it exists at all, you want it very limited forms. The vast majority of district court cases settle before they get to any kind of decision on the merits. So if you eliminate the opportunity to do it elsewhere and heavily de-incentivize people to file them there, then it's an advantage for plaintiffs.
All right, and then last question on this one is, when do you think we're going to hear back from the PTO on this October NPRM?
I say soon. I mean, I think they've been given the carte blanche by these, the Fed Circuit not addressing any of these mandamus. So I think that they're going to, hopefully they'll look at the comments and, perhaps give the patent owners a little bit more onus on their own patents. Like if you filed for one person, there has to be some stipulations, especially for this one and done. But I think that they might refine a little bit and have them come out soon.
So what's interesting is that the PTO was supposed to have a webinar about the NPRM in January. It was somewhat abruptly canceled, and we heard that it would be rescheduled. I have not seen anything indicating an actual rescheduling of it. I just got an email, it was either today or this morning, about other webinars about the PTAB that are being scheduled. Still nothing about the NPRM. So either they are not having that session anymore and just plan on moving to the final rule, or it's taking them longer than they imagined.
Well, they have to go through those comments, right, Jackie?
Right.
Yeah.
Yes, in the past, they always did do that. I will say that there was an announcement about listening sessions relating to the PTAB.
I think that's what
March
Roger.
30th, April 20th, May 18th. And I did wonder if they were doing that to somehow get feedback also on the NPRM or to pass along information, or I wasn't sure if they were they don't, like you said, they don't mention it, but the fact that they're talking about it is interesting. And I would imagine that would come up.
I would expect it sometime this spring, early summer. I don't think they're going to let too much time grow under their feet.
Yeah.
Now, I don't know that this is necessarily something we can anticipate, but there have been rule packages that have gone out that have been so poorly received that they have actually not gone forward with them. So that is at least theoretically possible. But the fact that they put it out there in the first place sort of tells you what they're thinking, especially in light of all the other stuff that we're seeing at the office.
And in light of the fact that messaging on a lot of things has not changed. I mean, the thread of quiet title, settled expectations, all of those other things has not changed since, early in this administration. And I just saw Director Squires speak in Utah last couple weeks ago, and he used those exact words. So I don't see that course changing too much. There might be some refinement around the edges.
I know we were thinking about talking about the recent precedential forward decisions, but one of the buckets where things have come out, as we were talking about, were this concept of settled expectations, and sort of what they've been doing with it. And one of the things that's come out of it is this idea of patents that are in force for fewer for more than 6 years may have settled expectations for the patent owner. And it's interesting because they have talked about, both parties should talk about their settled expectations. So whatever has happened that might have given them particularly settled expectations, that's one thing that, is important for stakeholders to understand. It's like, no matter what side you're on, now that they are putting settled expectations on the table, make sure that you talk about them. I think in the past, they surprised a lot of people with settled expectations that favored patent owners because nobody was thinking about that, and it wasn't anything that was in the AIA or discussed before. But at the same time, if that's where we are today, I think it is important, and hopefully it will matter if there are settled expectations on either side. So I think that's an important one to think about, is that hopefully when the element of surprise settles down a little bit, that both sides can think about how they can argue their case, and that they're equally taken into account.
Right, that's an excellent segue into our final topic that we're going to cover in 6 minutes, about recent precedential and informative decisions coming out of the director's office. I guess, Raghav, how does Director Squires' use of precedential and informative designations compare to how it was done even under Acting Director Stewart or former Director Vidal?
Well, I think the consistent theme between at least Acting Director Stewart and Director Squires is that the decisions, the AIA decisions that have been designated precedential or informative, have overwhelmingly been on the institution decision, which makes sense as it's the decision that is committed to the director's discretion. Very few of them relate to the merits of patentability. We've got the Revo decision and the Tesla decision that deal with claim construction, but still more on the line of how your claim construction arguments could impact whether you are instituted or not. On the ex parte prosecution side, we have a new precedential decision on Section 101 patentability, but that's the only one that deals with the merits of patentability nothing on the AIA side. There's also been decisions that have been de-designated, again, on the institution point of RPI.
Yeah, I think we're circling back to the original RPI. Back to the future.
Yes.
Yeah, we haven't talked about that, but one of the areas in which there's been presidential decisions was the de-designation of Shark Ninja, which had been in place since 2020, which basically, this is on the issue of real party and interest. And under Shark Ninja, the PTAB generally declined to analyze real party and interest unless there was an allegation that it would matter in terms of a time bar, a 1-year time bar under 315B, or otherwise it is stopped as of the date of the filing of the petition. And what the director did in September is he de-designated Shark Ninja, and then October he designated a Corning decision, which was a 10-year-old decision that basically returned that practice to what it was pre-Shark Ninja. So that means that disputes about real party and interests are now alive and well. There can be briefing, there can be all sorts of discovery, that kind of thing. And so if a petitioner doesn't list all of its real party and interest properly, basically that petition will not be considered until it's fixed. And if it is fixed, it can impact the filing date unless there was no bar at the time unless there was no bar in place as of the day that they fix it. So this can be a trap for the unwary if people aren't careful today.
And I think it'll be interesting, Jackie, and what I hope I see in the final rule package, especially with respect to the one shot, is the one shot rule is no challenge of the patent anywhere in front of the U.S. Patent and Trademark Office as a whole, right? But that doesn't square with the ability to file re-exams anonymously. And so I hope all of the practitioners have seen, the new cover form for re-exams where the attorney signing the re-exam actually affirmatively represents that the person behind the anonymity is not a real party in interest somewhere. And so I don't know if that's kind of their answer to that aspect of the one shot rule, but it will become very interesting. And I hope they really address it very fulsomely in the final rule package.
Yeah, I mean, I think they're trying to address the whole, look at the decisions on joinder, right? So they're not really, it's one petition. They're not letting people come in and piggyback or copycat, as they say, other decisions. So I think it's going to be a one and done. And if they don't get it in the rule, it's practically in practice right now.
Yeah. I mean, there's some cases that say you can do it as long as you wouldn't be time barred. So if you look at 315 itself, it specifically says that somebody who's time barred can join. But this says at the institution stage, as a matter of discretion, they're pretty much not going to do that, absent what they call extraordinary circumstances, right. If somebody's barred. And they also said that they will look for the purposes of fintive if somebody files a petition and motion for joinder. Normally they would just join as a party to the prior case that's already ongoing and instituted. But for the purposes of fintive, they will now look at that second petitioner to see what their date would be as if joinder didn't happen. And so potentially discretionary denial there as well.
Right.
All right, well, we're almost at time. So before we wrap up, I just want to thank Virtual Patent Gateway and Ashley and her team for putting on this year's PTAB Whispers program, assembling this phenomenal panel, and having done this for the fourth year in a row. It's been great. Working with this panel has been fantastic. And thank you, everyone, for attending. And if there are any from the panel, if there's any last-minute burning thoughts that folks have on any of the topics we've discussed today, you've got 60 seconds. Make them, roll with it.
Things change very fast, so keep updated through things like this.
That's another thing I would say too, is just to keep track of what's going on. All the options are still viable. You just know how to thread the needle, and make sure you stay on top of it. And there are ways to do that. You can follow the PTO's websites. They have subscription blasts that you can get to, and of course, talk to your attorney, because there's a lot going on, and there are people who are specialists who are keeping track of it in real time.
Absolutely.
Yeah, keeping track is the most important. Things are changing on a daily basis, and I say have faith, because as Jackie says, there's ways to get it. Once you start learning the new process, I think that people will start feeling more comfortable again filing IPRs, and once you just have to learn the rules, right? So once we figure out what that is, we'll get back to you and we'll do another webinar, right? Right, Jackie?
And who knows what will happen in the future? I mean, we saw drastic changes under this administration, could be different in another one too.
Yeah.
That's part of what's going on as well.
That's the one thing. When I went to the patent office in 1989, and wow, before that there was nothing. I was like, it was impossible to get a change. But now, whiplash.
All right. Well, thank you, everyone. And I believe this concludes today's panel.
Great.